Evil versus Evil Mannequin. File numbers 23-13612FH. Bring her on in. All right. Appearances from counsel.
Nate Carnes on behalf of the people.
And I'm Jeff Pierce. I'm here on behalf of Ms. Manicki. She's joining me at the table.
Thank you. You may all take a seat. Also joining us this morning is Mr. Brian Potter, distinguished gentleman from the Michigan Department of Corrections, as the probation officer on today's file. And what are we doing? Mr. Harrison, I'm looking at you now.
She is prepared to make admissions to all 4 allegations.
All right, thank you. Ms. Manicki, is that true?
Yes.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Ms. Manicki, you are charged here on 2 different forms that are called a request and warrant for probation violations, and I'm going to go over each one of those again. Count 1 alleges, and this is from the one filed on May 10th of 2024. That count 1 alleges you violated special condition 3.3, which requires you to notify your probation officer of any change of residence. And more specifically, it's alleged that on or about March 10th of 2024, you had been reported as homeless, and then from May 7th of 2024, you failed to update any residence or locations with your agent. Whereabouts remained unknown. Count 2 is an allegation of violating Rule 4 that requires you must complete outpatient and residential substance abuse treatment, and more specifically that by May 7th of 2024, you failed to attend such a program at the Sunrise Center. Count 3 alleges that you violated Rule 3, which requires you to make a truthful report to your probation officer monthly or as often as that officer may require, and that you failed to report on May 8th of 2024 thereafter. And count 4, which was filed on October 24th, adds a count 4 for violating condition 2.4, which requires that you are not to use any illegal or controlled substances, and more specifically that on or about October 27th, 2025, due to a positive screen, it proved that you had used methamphetamine. These are a combination of technical and non-technical violations. That last one is a technical violation. The other one, the previous form filed back in May of 2010, includes at least 2 non-technicals. That's important because once you're found guilty of either a plea or a hearing of a non-technical, the court's not limited to a sliding scale. That means is for technical offenses, for 1, the court's limited to up to 15 days. 2, the court's limited up to 30 days. For 3, the court is limited up to 45 days. For 4 or more, or for any non-technicals, the court is no longer limited to that sliding scale. In this, if you're found guilty, the court will re-sentence you on your original offenses. In this case, you were originally convicted of possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or $15,000, and operating a vehicle while impaired. That is a misdemeanor punishable by up to 93 days and or up to what was impaired. So what's the penalty? Up to $350. Okay. All right, and it's up to 90 days, up to $350. Been a while since I've dealt with too many misdemeanors. Anyways, if it's the operator while intoxicated, it's up to 93 days and a minimum of $100 to a maximum of $500. You understand?
Yes, sir.
Is that how you wish to resolve it? Now, by pleading guilty, you're going to waive your right to have a hearing, waive the right to have the prosecutor prove the allegations by preponderance of the evidence, waive the right to cross-examine any witnesses or review any evidence against you, as well as the right to present witnesses, evidence, or testimony, as well as the right to remain silent and not have that silence used against you. Do you understand?
Yes.
All right. Thank you. As to those four counts, they request and warrant for probation violations. How do you plead?
Guilty.
Before the court can accept that plea, I'm going to go over and ask you some questions to find out what you did that makes you guilty of that offense. However, before turning to that, and earlier, by the way, the operator while impaired is actually up to 93 days and up to $300, not $350.
300, okay.
I was wrong. All right, so the court takes judicial notice of the terms and conditions of probation that were filed in this case. They were issued by me on October 10th of 2023 and subsequently acknowledged by you on November 22, 2023. All right, so Ms. Manicki, were you on probation last year back in May?
Yes, sir.
And so it says you were homeless for a period of time, is that right?
I am still currently homeless, yeah.
Still, all right. And back in May of last year, did you stop reporting to your probation officer?
I did.
All right, and why was it that you stopped reporting?
I talked to him and, well, Mr. Potter, and I told him that I would be in rehab on May 7th, and he told me he was out of the office until then, and don't let him down, I better be there. And then my ride fell through, and I just got embarrassed and panicked, and I chose to run like a dummy instead, so.
Okay. And so were you supposed to go to the Sunrise Center?
I was.
And so when you were, I'm gonna say on the move, you didn't stay in contact with Mr. Potter, so it looks like
I
you got
did
arrested.
try to call him like twice in the first week I was on the run, but
Yeah.
got his voicemail, and I used that as an excuse, as the universe was talking to me to not call him no more, so.
Yeah, I don't think that's how the universe works, but,
No.
hold on. Yeah, it doesn't really seem to talk to you very well.
Panicked and I ran. Like a dummy.
And so when you were picked up here in last month, looks like they did a test and you tested positive because you had previously used some methamphetamine.
I did.
All right,
The day before I was arrested, I did.
all right, thank you. And when you were on the run, clearly you weren't telling anybody what your new address was or where you were.
Well, I really didn't have one.
I got it. It's kind of a silly one, but anyways. All right, Mr. Carnes, at least you provided a factual basis.
Yes, sir.
Are you aware of any promise, threats, inducements?
No, Your Honor.
And do you believe the court complies with court rule 6.445?
Yes, sir.
Mr. Harrison, do you agree with all three statements?
I do indeed.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The defendant is found guilty of the four counts on the two requests and warrants for probation violations. And now the question is, are we able to proceed to sentencing? I'll note that she's already served her sentence on the impaired. I know I gave her 90 days last time. And so we're really just looking at the operator while intoxicated. Mr. Carnes has got a curious look on his face, but I can look at this. Yeah, I'm just going to ignore your face from here on out. All right, Mr. Potter, can we move to sentencing right now?
I'm prepared to move forward on it, Your Honor.
Thank you. Any objection, Mr. Harrison?
No.
Mr. Carr, no, we're going to turn away from Mr. Carnes. Go ahead, Mr. Harrison, or Mr. Potter.
Thank you, Your Honor. Your Honor, the defendant was sentenced originally on 10/9/23 for controlled substance possession of meth, 10-year felony, and the operating impaired. On the felony, Your Honor, it was 24 months probation, 120 days jail. Guidelines were 0 to 17, 118 days credit, 118. With that, Your Honor, as shown in the probation violation, the defendant failed to go to treatment back in April of 24. We had a bed saved for her at Sunrise Center. This was in lieu of violation behavior that she agreed to go to the residential treatment and then absconded from that point. Your Honor, the defendant has a history. I looked up her pre-sentence report. She has failed to appear, prior probation violations, prior parole violations, and prior absconding. So the behavior is consistent with her prior history. With that, Your Honor, you know, I don't know how to feel about this, that the defendant was proactive and gave herself another bed for November 13th of this month at Sunrise Center. but I think it was premature as she's now taking a bed away from somebody else by reserving that bed, not knowing what the court's going to sentence her to. With that, Your Honor, we would recommend that probation be revoked in this case and the court impose a jail sentence.
Mr. Carnes?
Your Honor, it is troubling that the defendant had a bed arranged by DOC in the past and then just failed to appear. The department is working hard to get people into treatment, and then not only does she not appear, she absconds for over a year and then is testing positive. I think it's clear the defendant is not supervisable. I had also asked the court to consider the original conduct. She was pulled over for crossing the center line. Blood results came back with active methamphetamine in her system, over 300 nanograms. I think that means she's got a lot in her system while she's driving. That's troubling, and she had approximately 7 grams of methamphetamine that was submitted to the laboratory. Those weights include the packaging normally, so I don't know how it is, but all in all, troubling allegations. I think the 365 days jail and terminate probation.
Mr. Harrison?
Well, so much of the conversation we've had today is focused on the past. What did she do a year ago? What did she do shortly before that? What did she do that brought her to the police attention? What did she do that brought her to the court's attention? In the interim, I don't mean to cast aspersions or to speak negatively to anybody in the room, and that would include Mr. Potter, but I'm encouraged by the fact that one of the first things she did was designate her need for continuing her treatment. She doesn't really have any other way of expressing that. I mean, I've said it a million times, and now Judge Wiggins often re-quotes me on that without giving me credit. There are no atheists and popsicles. I mean, it's easy for every person in here on the drug charge to say, "Oh, my addiction had me in a grip, and what I really need is treatment." So she went beyond that mere statement to say, "Look, this is next level. I'm serious about it." And I don't know if the court can see. It's often an advantage that I have is that I do get to spend a significant amount of time with clients, with defendants, with people in the system. And specifically with regard to Ms. Maneke, it's night and day different encountering her today than I did even a couple of weeks ago or a month ago when she first came back to visit us here. I believe she's cleaned out, she's made progress. She's been able to accurately assess her situation, and the only looking back she's doing is to say, "I'm 41 years old. I'm middle-aged, and I need to live out the rest of my days on this planet in a more positive manner." Her 90-year-old grandmother serves as inspiration to her in that regard. All of that notwithstanding, Your Honor, I think it's easy to say, well, clearly she's not taking any of this seriously, and I'd even concede that maybe she didn't at the time. Now, and that's really the important time to focus on in the whole continuum here is, what do we do from this day forward, not from some day in the past forward? So yes, I think a jail sentence is appropriate. I think she would even nod her head if I asked her to express support for that idea. I understand why they want to revoke probation, why they feel frustrated in that, as noted, even by Ms. Maneke herself, the department went way out of their way to accommodate her need for recovery and placed her into treatment that she was unable to attend. And thereafter spiraled or snowballed, or whatever metaphor you want to put to explain how this problem got much larger than it ever had to be. So I would say at this point, I don't know that jumping from 120-day sentence, which obviously the court considered 0 to 17 sentence prior. So in effect, her good cause or her prior record on probation and perhaps bond was already factored into the initial decision in this court. There are subsequent instances of that same conduct, which would allow again the court to establish good cause and impose a jail sentence in spite of the intermediate sanction guidelines. I leave it to the discretion of the court. The proposed 365 days, I forget who said it, I believe it was Mr. Carnes, seems like too big a leap under the circumstances based on the guideline, the prior sentence, and frankly, her forthrightness with the court here today. Thank you.
Ms. Manicki, while I don't know if there are any words left in the English language not used by Mr. Harrison, is there anything else you wish to add?
I, believe it or not, have been trying to take care of my absconding here for the last probably 6 to 8 months. I've been trying to work it over with my kids and my fiance and everybody that I need to go turn myself in. And because I'm just a giant letdown to my family, I felt like I was letting them down by turning myself in. So that prolonged it. But I am grateful that I am here. It has given me a time to clean out, and my mental health is improving compared to what it was before, which has been really bad. And I'm just relieved actually that I'm no longer on the run, because this is something I did want to take care of as soon as I possibly could.
All right, so Ms. Manicki, I'll probably keep the atmosphere a little bit light today, and I do that in part because you helped do that. But I also think, from what I'm hearing from you, is cyclical issue. Yes, failure to report. Yes, bond issues, probation violation issues. I got all that. There's something in you that seems to argue with yourself, right? Like you said, I made the call, he didn't answer, universe was speaking. Yeah, well, I understand that. So I think you're aware of the issue, but then I also can't tell which, and I know you're not schizophrenic, so I'm not trying to be rude. We all have multiple sides of ourselves. But within yourself, when you're making those arguments, I'm worried about which one's going to win on that particular time or particular day. I don't know what that is. I don't think, by the way, I don't have any reason, I don't remember the entire your criminal history, but don't have any reason to think you're a bad person.
I'm not a criminal. I'm just, my whole arrest record was
Drugs.
substance abuse issues. The first had is alcohol, and the second had is methamphetamines.
Yeah.
That's all it is.
Those things tear me apart. I write about them, I talk about them, I speak at places about, addiction and the programs that we need, the few programs we have, and it's just a horrible cycle, and it really kills me personally to see it on the faces of people. When they first get arrested, when they come in today after they've had a couple weeks to clean out. Well, Mr. Harrison has said it out loud, your age. So I know by repeating it, I'm not breaking the rules. It's 41. And you got a lot of time. A lot of time to figure this life out. Stop arguing with yourself. Make sure you're finding ways to deal with things. Think about things. So many tools out there. There are so many people, I promise you, who care. I guarantee you Mr. Potter does. I guarantee you even Mr. Carnes, with a funny looking face today, does. Promise you I do. So I don't know what to do today. I want to keep putting you in rehab. But I'm afraid you'll get there and not participate.
I've never ran from rehab. I have a good rehab standing actually. I left one time last year from Bear River after I contacted Mr. Potter because I did not like the way it was ran. They were not meeting my needs. I felt.
Well, that's another problem. I mean, I know each program has its pluses and minuses, and different approaches.
I did stay and remain in contact with Mr. Potter until I had his permission to leave. So
Here's what I'm gonna do. And so far, I demonstrate, by the way, that everyone's recommendations are important. What I'm gonna do isn't gonna comply with anyone's recommendations. So pay attention. The court extends, this was a 24-month period of probation. The court actually is going to extend probation to a total of 36 months with the same original terms and conditions, except for what I've changed here in a moment. The court preserves all fines and costs. The court sentences the defendant to 365 days of jail on count 1 with 118 days of credit. I find that the sentence for count 2 is already been served, so the extension only applies to the possession of methamphetamine. Now, within that sentence, the court will, if Mr. Potter is able to actually get you into the program or a program.
I actually have a better.
No, he told me, I don't, that's what I'm saying. If he is able to, yeah, I got it, hold on. If he's able to arrange it and can work with Wex Express to have you picked up from jail and delivered directly to the program. So I know you go. All right.
Okay.
Now, if you abscond, I want you to note something here. By going to 365, and then if I let you go, if we're able to get you into rehab and you abscond, or you leave the program unsuccessfully, because I've already maxed out your jail, there's only one place left to go. And Ms. Manicki, where is that?
It's fine. I've already been there. I would not like to go back. So
Yeah. I hear prison isn't the greatest.
it's not.
No. The only other option here, and I didn't ask Mr. Potter this. Mr. Potter, was she boot camp eligible? Was she?
No. No, Your Honor.
All right. All right. I forgot to ask that, but I figured based upon prior cases, if you had been, I know you're not eligible 365. If I didn't give the 365, could she have gotten boot camp?
No, Your Honor, she has a prior prison sentence.
All right, thanks. I did not know that.
Yeah.
Oh, that's right. She just told me that. Anyways, Ms. Manicki, that's the next place, and I'll send you without even a drop of a hat, without even a whisper of thought. I'll probably interrupt Mr. Harrison next time in his closing argument. Just tell him to stop talking.
Okay.
Now I'm joking a little bit because I want you to understand that I care.
I
But I'm
appreciate
gonna give you a chance at rehab, and it's gonna be a real chance. And if you mess it up, you're gonna mess it up for everybody, including yourself. And I'm the one person who will say, for instance, if people bring in their kids and say, hey, look, I got kids, it hits me the wrong way. I think, oh my gosh, I better send that person to prison to keep them away from the kids and to help those kids. So I'm eager to do that next time. I could even do it today. All right, so that's
Your
the
Honor.
sentence of court. Yes, sir, Mr. Potter.
Because of the 365, normally you would tell me do 180, but in this case, am I trying to get her to that bad on the 13th?
No, I'm gonna say it should be to 180, at a minimum of 180, and then that rest of the time hangs over her head. So for instance, if she comes back and she violates and gets and I issue a warrant, she'll have to serve the remainder of the period of time, and then whatever we sentence her to, if she violated on probation again.
Thank you, Your Honor.
And she hasn't had any other probation violations here, but Mr. Potter, didn't you tell me there was one that was informal?
Yes, Your Honor. That's why
she's
she was
got-
going to treatment. She was going to treatment
Yeah.
originally in lieu of
Yeah.
violation, Your Honor.
Yeah, so that tells me that she's already got at least 2 prior technicals. No, 3, because now she'd have 3. So any violation of probation is now an automatic, I'm no longer capped, which means I can send it. Okay?
Okay. I appreciate you.
Ms. Manicki, I'm worried that you're gonna argue with yourself when the one bad side's gonna win.
My rational thinking usually wins out. It's just how I
Well, I hope your rational thinking works out before you mess it up.
can't
Okay.
let the influence of my family members' feelings and me doing the right thing gets my emotions. That's
Your
what I
family,
feel.
yeah,
Take care of yourself.
just
They feel
pretend,
I'm being selfish by trying to do the right thing and take care of stuff, and I feel bad because I made them feel bad.
I'm older than you, I think Mr. Harrison is. Pretend I'm a really young uncle, so that way now I am seen as a family member. And this family member is telling you, don't mess it up,
Okay.
all right? And I'm the family member who has a gavel. I know we're joking a little bit, but I want you to really do well.
I'm totally gonna refer to you as Uncle Elmore.
All right, hold on. You have the right to appeal your conviction and sentence that is typically done by filing a claim or right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you keep the bottom half of the copy of the document I see that you have in your hands. You return within 42 days. If you choose not to appeal, simply dispose of your copy of the document. Please do not flush it in the toilet in the jail. Thank you. We are adjourned.
Thank you, Your Honor.